Good evening, everyone. Welcome. Thank you all for being here tonight. I'm going to call this regular meeting of our Town Plan and Zoning Commission to order. Today is Monday, October 2nd. It is 6:32. Apologies for being a few minutes late. My name is Rob Klee. I'm the chair of our Woodbridge Town Planning and Zoning Commission. Other members of the commission that are here with us today include Paul Schatz, Kathleen Hunter, Yoni Zamir, Jeff Kennedy, Aaron Hoffman, and Shadi Nujim, and we may have Andrew Skolnick joining us momentarily as well. We are ably supported by Chris Sullivan. Nice to have you back. Good to see you.
You like short meetings, you know.
Chris is our town land use analyst and zoning enforcement officer. It's nice to be here in person, and it's nice to see all of you here in the audience. Thank you for coming tonight. Our agenda has been available on the town website. Tonight we have two public hearings scheduled. The first is a special exception permit for the excavation, removal, filling, and grading at a residential site located at 9 Acorn Hill Road. And the second public hearing is a special exception permit to erect two wayfinding or directional signs at the intersection of Bear Hill and Seymour Road and the intersection of Acorn Hill and Seymour Road, brought by the Kriz Farm Ice Cream establishment. Then we have some additional work in our work session. No other new business came in since we got this. Great. Good. So let's start with our public hearing for 9 Acorn Hill Road for a special permit for the excavation, removal, filling, grading, and processing of earth material. So thank you very much for the applicant. I'll give you a moment to get set up, and once you're all settled, if you could sign in and introduce yourself for the record.
We should just note for the hearing record that the plans were referred to your consulting engineer, Solo Engineering. There were two documents that were sent to you by him, which I forwarded to you today. One was a letter dated September 28th with comments, and then today's letter is dated October 2nd. And it just notes that there were revised plans that were received, and all previous comments have been addressed on those revised plans.
Great, and Chris, so revised plans other than the one we have in our packet.
And I think we're going to see those tonight. If they can zoom in on it, yep.
Okay, good evening, Mr. Chairman, members of the Commission. My name is Robert Weway. I'm a licensed professional engineer with the firm of Codispodian Associates with offices at 263 Boston Post Road in Orange, Connecticut. We're here tonight on behalf of the applicant, Jesse Warble, and also Giuseppe Coletta is here to answer any questions that the Commission may have. The owners of the property are Paul and Mary Blum. The applications before you tonight represents the last lot to be developed in the Frederick Blum subdivision, which dates back to 1987. The lot is 1.53 acres in size and has a frontage of approximately 210 feet along Acorn Hill Road. The property is presently undeveloped and mostly treed. There is a cleared area up on the top middle portion of the property up on top of the knoll. Along with a dirt access road that comes in off of that Acorn Hill Road to get up to that top portion of the property. The proposed development is for the construction of a single-family home, driveway, septic system, and a private well on the property. All told, there will be approximately 4,400 square feet of impervious surface area added to the property. We're here tonight to request a special exception to the earthworks provision of your zoning regulations, which will exceed the allowable 100 cubic yards for the project. The need for the earthworks removal is due to the fairly steep slopes which exist on the property, leading from Acorn Hill Road to the interior of the property. The driveway will start at approximate elevation 330 and rise to the central portion of the site, which is approximately at elevation 340, or 348 at the garage. The driveway itself will be filled, will consist of mostly fill as we enter from Acorn Hill Road, and then it will progress towards a cut situation as we get up near the house and the garage portion of the property. The septic system has been designed for a 4-bedroom house and has tentatively been approved by Quinnipiac Valley Health. As mentioned before, the construction will add approximately 4,400 square feet of impervious surface area. With that, you could expect increases in both peak rates and volumes of runoff due to the impervious surface coverage. We have developed a rather detailed stormwater management plan to address water quality, volume of runoff, as well as peak flow controls or peak rates of runoff for the property. And the stormwater management plan basically consists of 2 collection systems or 2 stormwater management areas. System 1 is composed of 5 units of 4-foot by 4-foot by 4-foot dry wells, and those will basically receive runoff from the roof area by itself. The second system will collect runoff from the driveway as well as the tributary landscape area and be directed towards an infiltration system as shown on the drawing. And that second system will consist of 14 units of 4x4 galleries also. Both of the systems will fully store and infiltrate the water quality volume of runoff in accordance with the 2004 Deep Water Quality Manual. The galleries have additional capacity built into them, and the additional capacity will provide for storage and infiltration of the flows from the 2 through 100-year storm events, such that a 0 increase in runoff has been produced for all storms that were analyzed, the 2 through 100 year. So we provided for a 0 increase in runoff as well as a reduction in the volume of runoff that will be leaving the site as a result of the development. We've also provided a detailed soil erosion and sediment control plan. The major elements consist of a mud tracking pad at Acorn Hill Road at the driveway entrance, silt fencing at all the downstream edges of the graded areas, as well as drainage structure protection, either silt sacks or hay bale protections around the proposed catch basins. We've identified a stockpile area for topsoil on the property, as well as identified areas of permanent vegetation for the property. The plan and the drainage report have been reviewed by your consultant. The initial review had a few minor comments on there. Probably the major one with respect to the drawings was the inclusion of dissipators at the ends of the pipes. So we've added three different dissipators on the proposed plans. And those plans were resubmitted to your engineer on this past Friday, and he gave us a subsequent review dated today, indicating that all of his concerns have been addressed with the revised plans. So with that being said, we would also ask that this commission act favorably on the special exception request and grant the site plan approval. If there's any questions that the commission may have, I'm certainly here to answer them for you.
Thank you very much for that presentation. Any questions from members of the commission before I ask one? Could you actually just walk me through what a dissipator is, and why that was something that our consulting engineer thought was important to add?
Yeah, I think, well, the dissipator is at the end of the pipe where you would have either, the pipe or a flared end structure. You basically have concentrated flows that come out of that. And
those are like flows from the roof gutters go into a pipe and then?
Well, the
are
roof itself, there is no outlet pipe for that. Those galleries have been designed to fully contain the 100-year storm, so there is no outlet pipe for the roof galleries. The two pipes that we do have the outlets on, there's a low point in the driveway, which is picking up upstream watershed area, and that is not going through our collection system, so we're basically collecting that at a yard drain, piping that under the driveway, and then that's going to be discharged adjacent to the town right away. So in that particular location, he was asking to put in like a riprap pad, in essence, is what that is.
So, in essence, instead of rushing out of that pipe into the public area?
Yeah, I mean, the
it would-
water's still going to come out of the pipe. The riprap will help to reduce or diminish the velocities that are coming out of the pipe, and hence, if you go along that pretense, it would minimize the erosion that occurs down through that area. You know, that comment is pretty typical of any time when you see a pipe. I did have a conversation with Jim, and I explained to him that for the particular flows that are coming off of this site, the flows are so small, there's no formula in either the DOT manual or the water quality manual that lets you size the riprap because the flows are just so low. So, we came to an agreement that we would put riprap in there on the one pipe, and then for the other one, because there is no defined channel on any of those, so what we put in is basically a level spreader. So it's either going to be 6 feet wide by about 18 inches wide, and I think we went down 18 inches on the depth. And that's basically, it's a trench. It'll be excavated, backfilled with 1-inch broken stone, so that any of the overflow that comes out of the system for that also would basically flow down through that, be allowed to infiltrate into the soils, and then spread out over a more uniform length. And again, it's important to bear in mind that the overflows from the gallery system, and to put it into context, for a 25-year storm, we've only got it's 0.1 CFS that's coming out of the system, so it's a really small flow that has to get handled through there. But we did add those details to the drawing, and the notation's been called out. And then he had two other comments in there. He was just asking for some additional notations to be added to the drawing. One was to basically have the design engineer provide a letter upon construction completion, just to indicate that the stormwater management system was installed in general conformance with the design plans.
Thank you. Helpful. Other questions from members of the commission?
So right now, there's no abatement systems in place, right? I mean, it's just undeveloped.
Yeah, it's
land,
basically
so-
an undeveloped site. There is the drainage soil, which is that kind of traverses through our low point in the driveway. So there is some directional flow that gets out to Acorn Hill through that area. The remainder of the property is all pretty much sheet flow going down the slope embankments.
Other questions, comments? I'm seeing none and hearing none. Anything else you'd like to share with the commission before I let you go?
That's a quick summary.
Excuse me, do you have a set of the revised plans that you can?
I could leave this set here. If you need more sets for the commission members, we could.
I just need one for the record.
Okay.
Terrific. So going once, going twice, going 3 times for the commission. Any further questions? Hearing none. So thank you very much. I'd like to now shift to the public comment portion of this public hearing. This is for the purpose of excuse me, listening to comments from the public. Any member of the public who's interested on offering a comment will have 3 minutes for their brief statements to be entered into the record. During this time, the TPZ members and the applicant will not be answering questions raised by the members of the public. Note your public statements and any written comments that were submitted to the town, of which there were none.
I just had a phone call today and she was gonna send an email, but it didn't come through.
Okay. Those, if there were any emails or other written comments, would be part of the public record for our consideration of the application. And as a reminder to everyone, any off-the-record communication with a member of the commission on the merits of the application is prohibited. So if any member of the public would like to come forward, and I'll ask you to vacate that seat just in case. We'll ask you to keep your comments brief and focused. And if there are any members of the public who have comments on the application of 9 Acorn Hill Road, please come forward. I see none. I'll go once and twice. Any opportunity for anyone who wishes to comment on the public hearing for Acorn Hill Road? And we have no public comment. So having had our public hearing and offered an opportunity for public comment, we now need a motion to close the public hearing portion of the Acorn Hill Road Special Exception Permit application related to our excavation, removal, filling, and grading rules in our Woodbridge zoning regulations.
So moved.
Moved.
Second.
Sorry, Yoni beat you. Moved by Paul, seconded by Yoni. It's been moved and seconded. Any discussion of the closure of the public hearing? Seeing none, all in favor of closing the public hearing, say aye. Aye. Any opposed? Any abstentions? Thank you for that public hearing. We will address the public, address the special permit application during our work session shortly after our next public hearing. But thank you to commission members for listeners. Thank you to the applicant for your presentation. And so that one is done.
That one's done.
Great. So next up is our public hearing for the Kriz Farm Ice Cream Special Exception Permit application for wayfinding signs located at Bear Hill/Seymour Road and Acorn Hill/Seymour Road, which are signs to direct folks to the Kriz Farm Ice Cream Store at 13 Bear Hill Road in Bethany. And who would like to begin the presentation for the applicant?
Good evening, Mr. Chair. My name is Vincent Marino. I'm an attorney admitted to practice in the state of Connecticut with the law firm of Marino, Zabel, and Schellenberg, located at 657 Orange Center Road in Orange, Connecticut.
And I'll give you a moment to sign in.
Thank you. Thank you, Mr. Chair.
You may proceed.
Mr. Chair, I'm here this evening seeking a special exception permit for the installation of two directional signs located at the corners of 1 Acorn Hill Road and across the street diagonally at Bear Hill Road. If I may share with the commission before I get into the application, I took the liberty of going out to the two sites today and taking some additional pictures, just to try to give the commission some perspective of these signs.
Thank you. Chris, you have a copy for...
I have a copy.
Thank you.
So, Mr. Chair, pursuant to Section 4.5.d of the Woodbridge zoning regulations, an applicant must obtain a special exception for a sign permitted under tables 4.6 or 4.7 and Section 4.5.h. Under your regulations, Section 4.5.f2 provides that signs in Table 4.6 are permitted for non-residential uses in any residential district, such as religious institutions, historical societies, libraries, museums, art centers, historical societies, schools, municipal uses, and nonprofit agencies, provided such sign complies with other provisions of section 4.5. Under table 4.63 of the Woodbridge zoning regulations, a freestanding sign erected or placed perpendicular or parallel to the public street or highway to which the building or structure fronts or abuts, provided that the sign does not exceed 5 feet in height or 40 square in area. But a special exception is required. The applicant is entitled to one freestanding sign per street frontage and 20 square feet in total area per side. So what we're before you tonight is seeking a special exception permit for the installation of two, I call them wayfinding signs, directional signs, for the Chris Farm Ice Cream farm located at 13 Bear Hill Road in the town of Bethany. Now, my client's property, and my clients are here with me if you have any questions for them, is located approximately 800 feet north of this intersection. And they have heard from customers saying that it's difficult to find their farm, but that these signs have provided the customers with the direction to locate the establishment. The first sign is located on the real property located at 265 Seymour Road. I call that as location 1. The second is diagonally across the street at 1 Acorn Hill Road. Attached and submitted with the applicant, with the application, are the consent letters of both owners of both of these residential homes. And those are attached to the application as exhibits G and H. The proposal is to install, erect, and maintain the signs, the first one on the southeastern corner of location 1, which by measurement from the perpendicular is in from the corner of that intersection 8 feet going to the north and 7 feet going to the east. State DOT has inspected that sign and is fine with the location of that sign. That sign does not in any way impede or interfere with traffic concerns. The second location at 1 Acorn Hill Road is, again, diagonal across the street, and that is in from both perpendicular of that corner, 20 feet in from the street line. So again, in no way interfering with traffic or public safety concerns. So the two signs comply with your regulations. They are permitted under your regulations by way of this special exception, and we believe they further the purpose of your sign regulations, and that is to promote public health, safety, and welfare. It helps move traffic along off your Woodbridge roads to my client's establishments and prevents their lost customers from wandering through the streets of Woodbridge. So we're here tonight asking for your approval. And I understand that this has received some attention over the last couple of months, but we believe that this was the right forum to come to hopefully resolve those issues. We're here tonight to answer any questions. I did not submit a site plan because this is two separate sites. Attached to my exhibit, attached to my application, I attach GIS mappings of the intersection to show, so you can get a perspective of where those two signs are located. Again, the Chris Ice Cream Farm is located about 850 feet north of the intersection of Seymour Hill Road and Acorn Hill / Bear Hill Road. And as you'll see from attachment D, those two signs do not obstruct traffic and are, one is facing diagonally Acorn Hill Road and the other diagonally Bear Hill Road. So we believe that under your regulations, both signs are permissible. If you have any questions, I'm happy to answer them, but otherwise I believe this should be a straightforward application.
Thank you very much for the presentation. Do any members of the commission have a question for the applicant?
Just a couple. Attorney Marino, is the signs that are depicted in these photographs, are those the signs that are to be permanently installed?
Yes, sir.
Or just examples of what they would look like?
Those are the signs to be permanently installed.
And the first, not the first photo, but one of the photos that I'm looking at shows two signs in it. The one on Seymour Road, I assume the smaller of the two is not included in your application?
No, it is not. I noticed that today when I was out at the site. It looks like a little lawn sign was put in there. That is not, the applicant is seeking the two signs, the larger signs. That smaller sign would not be included in this permit.
And how would they be permanently affixed and anchored?
So the one that is at the one at 265 Seymour Road was affixed to the resident's fence. The resident has since taken down the fence, but left the fence post. If you look at my submission from today, for the fourth photo, on the right, you'll see the kind of the fence post is kind of in the ground. That's the right, I'll call it post for the sign. The left post is a green stake that would normally be used by, for like a chicken fencing or something along those lines.
Is that how it will remain?
At this point, there are no plans to put any permanent foundational posts in, but we're open to the commission's suggestions, if you have any, for those posts. But at this point, yes, that's how it is proposed to remain. And across the street, diagonally, you can't tell because it's in the plantings. But again, it's two green stakes that support the sign.
Can I ask, so in attachment J to your packet, I see that there's the Connecticut Grown Agricultural Direction Science Program. Are there plans to get a sign like that going at some point? Is that?
Not at this time, and not part of this application. That would be governed by the state, Department of Agriculture. At this point, no, we're just seeking these two for purposes of directional signs. I actually found that these are more easily seen than those state signs, which tend to kind of blend into the background. And that's why the applicant's here seeking permission for these two signs.
You call these signs wayfinding signs, but are these actually advertising signs?
Well,
Is that-
I call them wayfinding signs because you see how that direction, that they're on the corner where you have to turn, and they do have an arrow pointing in the direction of the farm. So they're not intended to be advertising; they're intended to be directional. And I would point you to the sign with the arrow where the ice cream is listed as directing traffic to make that left or right onto Bear Hill.
Isn't there already a sign directly across the street from the Seymour Road sign for Woodhaven Country Club?
There is.
That particular sign is not, excuse me, on the highway setback and is therefore subject to an encroachment permit from the state of Connecticut. It is not under the jurisdiction of this town.
That was actually raised to me earlier today, that there is that sign, I'll just say it, for the golf course, that has been there for some time. This is, in our view, no different. And again, state DOT has inspected both of these signs and does not have any issues with them.
So I was wondering if you could walk us through our zoning regulations and how they apply. And I know you refer to different sort of parts, and granted, I'm not going to call our sign rules crystal clear, but let's start with the basics.
Yeah.
What zone are you in?
Yeah, yes, so if you turn to attachment L, I think, HI, attachment I. I attach your zoning regulations to my application, and we can walk through them together. So of course, the purpose of, we start at the beginning, section 4.5. The purpose is intended to promote the public safety, welfare, providing standards to control the location, area, number, illumination, and overall design of signs, and in order to prevent undue distraction to motorists and pedestrians. To ensure compatibility of the signs with permitted land uses, to provide reasonable standards by which uses within the various districts may relate their function to the public, and in aid of preserving and enhancing the aesthetic and historical values of the community.
Okay.
So
And my question, first question, what zone are you in?
we are in a residential zone.
In zone A, I believe.
Zone, let me go back to my application just to confirm that, but I believe I listed that there. Yes, Zone A. Okay? So, under your section D, 4.5D, so it's on the next page. Pursuant to tables 4.6 and 4.7 and section 4.5H, a zoning permit or special exception for a sign shall be obtained for the commission, from the commission or its duly authorized officer prior to the erection of or installation of any sign except for, and it lists the exceptions. The regulation goes on to provide that signs listed in your table 4.6 are permitted in a residential zone with special exception permit. And number 3 on that table, a freestanding sign erected or placed perpendicular or parallel to the public street or highway to which the building or structure fronts or abuts, provided that the sign does not exceed 5 feet in height or 40 square in area. So the subject signs are 4x4, that's 16 less than the 20, so it's compliant there. And so we're below the 20 square feet that is allowed under 4.6. So then it says, provided that you comply with all other requirements of section 4.5. You go back to 4.5, and does it fit within the character of the neighborhood? We believe it's more compliant with that than any other directional sign would be, because it's advertising a farm right in the immediate neighborhood, right up the road, about 800 feet. And both property owners upon which have permitted the signs are in support of having these signs on their property. They're not intended to be advertisement signs. They're intended to point the driver in the direction of the farm, and again, to move traffic to the farm so that people are not lost. We've heard anecdotally from people in the neighborhood that without the signs there, motorists would stop at a house and knock on the door and say, "Do you know where this farm is located?" Farm is located. It's happened a few times. This actually prevents that in this immediate area, because it again draws attention to the eye because of the color of the sign. It sticks out nicely against the green background and directs traffic without interfering with anyone in the neighborhood. So,
But I guess my narrower question, you seek to have table 4.6
Yep.
apply, and I'm having trouble understanding. Table 4.6 is about signs permitted for non-residential uses in A, B, and T3 zones. But these are residential houses, so they are residences. I would have thought that those would be a sign for something like a church, a synagogue, or something that, or an elementary school, or whatever that happens to be in our zone A and is identifying the things happening on that site, the name of the school, the name of the church, versus these signs which are pointing to a business elsewhere that isn't that residential house's business where the sign is located. That's what I'm struggling with, to make
Right, but
sure all these things
your
align.
regulations don't speak clearly to that, right? They don't limit the signs, and actually, there was much discussion about this before the ZBA. And the argument ultimately, and the decision, that although there was no action by the ZBA on this, the sentiment of that board was that this approach under the special exception permit, since the regulations are not clear on what the chair has raised, that it appears that these signs very well could be permitted under section 4.6 of your regulations, because it does not say advertising, a sign advertising with businesses or churches or charitable organizations within the zone. Your regulation does not address, is not written in that way. It's simply, you go to your regulations.
But in section F, which signs permitted in residential zones, and F2, it describes the signs in table 4.6 are permitted for non-residential uses in any residential district, such as religious institutions, libraries, museums, art centers, historical societies, schools, municipal uses, and nonprofit agencies, provided such signs shall comply with other provisions of 4.5.
Yes.
So how do I read that section?
So-
It's not limiting table 4.6.
So the signs in table are permitted for non-residential uses, so we have a non-residential use in any residential district. What does,
But,
in any,
but not, but I'm sorry to interrupt you, but the non-residential use there refers to, I would say, the religious institution, the library, the things that are not residences in our, they're non-residential uses in our residential district.
which could include a farm. A farm could be
Sure.
a pre-existing,
But these signs are not on the farm, they're on a house near the farm.
but signs are permitted for non-residential uses in any residential district. Doesn't say where it's gotta be located. It just simply says a sign for a non-residential use is permitted in a residential zone. And, so the signs listed in 4.6 are permitted for a non-residential use. We got a farm, it's non-residential use. So the signs in table 4.6 are permitted in any residential district, right? So it depends on how you read that sentence as where, does the non-residential use have to be in that district? Or is that the sign is permitted in that district? I read it as the sign is permitted in that district for a non-residential use.
I have to say, I think it's pretty clear in the signage 4.5, section B, the applicability, that, it does say that the sign's design, is to sell products permitted by these regulations to be produced on the premises in the residential district. So wouldn't that suggest that the signs need to be, has to be on the actual place where the products are produced? To me, that's very clear.
Then that
So if you
totally
could-
makes 4.5F
I mean, the table.
meaningless, because, there's no limiting location in that language of 4.5F, and that's why it requires special exception approval. So that, there's nothing in this exception to your rules.
But explain within the applicability how the sign is okay to be on a property where the products are not produced, because here it does say that you have to have a sign designed to advertise the business conducted on the premises in the business, in the or designed to sell products permitted by these regulations to be produced in the premises in a residential district. This is a residential district. So to me, that clearly says that if you're gonna have a sign in a residential district, then the products have to be produced on that district. And if it's not produced, that means it's not permitted.
But your regulations don't provide that.
I'm reading them.
But that then renders your sign regulation under your special exception permit process as really somewhat more confused. Because if you were limited to posting signs only on parcels where you actually produce the product, then there would never be a sign anywhere in your residential district for non-residential use, except for the site where the product is produced. Right, under that reasoning, and then you wouldn't need this section at all. So,
Well, the last line of that section is except as permitted by the provisions of the section. So this is saying you can't do any of these sorts of things except as permitted by section 4.5. And to me, it's in line with my questions about if you were, my temple, which is on Rimmon Road, it's surrounded by residences. It has a sign out front that identifies it as a temple. There isn't a sign across the street or down the road pointing to that temple. It's only allowed to have the sign at the location where the actual institution is doing its work, which is how I read this, and the things that are approved by these regulations would be a farm in town is definitely allowed to have signs on their farm saying we're this farm in town, advertising and highlighting the work that they're doing there. The challenge you're hearing from us is this is very close to that, and literally 800 feet away. You've sort of identified that, but it's in front of two residential houses that aren't in the business of farming or ice cream sales.
exactly, and because under 4.5F, the reg doesn't say it must be on the site. I understand what I just heard from an argument standpoint, but you wouldn't need F. You would simply rely on B. And F would be unnecessary to have in your regulations if you only needed B. By the inclusion of F, subsection F, the regulations are taking one step further and saying, notwithstanding 4.5 A, B, C, or D, or E, signs are permitted in residential zones specifically for under 4.6 for non-residential uses, and then they give a description, not an inclusive description, but an example of the number of potential uses, provided you comply with the other provisions of 4.5. And, this is compliant in area, in size, and while it's not being produced on this site under 4.5F, it is a non-residential use posted on a residence. And I understand the conflict, but I think that by reading it so strictly, by saying, well, what about B? You're then saying your regs don't require F if you rely just exclusively on B.
So let me take it hypothetical the other way. So let's say you're allowed under this as long as you meet with the requirements of it not being more than 40 square feet, not to advertise a wonderful ice cream store, which we can all get behind because ice cream is delicious. Let's say it was someone else who wanted at their location to advertise the liquor store downtown, and say that this is an opportunity to go have liquor, or the new smoke shop that's actually going in on the New Haven, cross the line, a new marijuana dispensary. Are we then, if all of those signs comply with the 20 square feet and they come in for a special exception permit, we're in our residential zones, we should allow for people to now say just a mile away is a new marijuana dispensary to be located in the Stop and Stop shopping center in New Haven.
I would say that there's a reason why you use the special exception process. and that is to afford this body some discretion in whether or not to allow a sign to be located. And where you have a use that is so ingrained in the culture of this community, the Amity community of Orange, Bethany, and Woodbridge, farming, that there should be, that should be taken into consideration. This is not advertising marijuana or liquor, or this is advertising a local farm in the Amity community. And so utilizing your special exception discretion, you could say, when the liquor store comes forward, this is advertising for a local business, and it's something that's not permissible in our residential zone. However, where this sign is promoting the historical culture of a community, the farming activities of a community, that we should lean in the direction of what our community roots are and support that local farm. And so I could see, Mr. Chair, the concern, but I think that's why the commission was wise to use the special exception process, so that you could draw the distinction between just any use and something that belongs in the residential zone.
I'd like to, and again, apologize to my fellow commission members that I'm asking a lot of questions, but I wanted to follow up on Yoni's question about the Department of Agriculture has a specific program statewide to promote our wonderful local Connecticut-grown agricultural operations. Why wouldn't that be an option here instead, which is a sort of state-governed, is Seymour Road a state road? I thought it was, yeah. So isn't that an option instead, to use that Connecticut-grown signage to point in this farm's direction?
They would be allowed to ultimately, I believe it's within 5 miles of their farm under that program, to put signage up, which is much more expensive when you're selling ice cream. And again, tends to fade into the background. You know, they're standard signs that don't really stick out. Might that be something that they explore going forward into the future? But for the present time, to address the issues related to the locating of this facility, this farming facility, these signs, we believe, provide the best option. But that's something that they would look at in the future. But again, problem is that, again, they're not, I think I may have attached even what those signs might look like. You know, they tend to be just kind of, yeah, exactly, like that. And again, not an inexpensive program.
Other questions from commission members?
So you're saying that that sign, the Connecticut grown one, would cost the applicant, the client, money in order to apply for it? Yeah.
Yes. Yeah. It's not, the state doesn't give them out for free.
How much is that process?
Excuse me?
How much is that process?
When I looked online, I thought it was $1,500 a sign. Yeah, I thought it was $1,500 a sign.
So this area where these signs are, I'm somewhat familiar with it, drive by it. So you have Bethany, Seymour, and Woodbridge all right. How far apart are the actual municipal boundaries in the area that these signs are?
Bethany is, again, the Bethany line is about 850 feet up Bear Hill Road. Seymour is down the road about a mile. About a half mile down the road. That would be Seymour Road going west.
Okay. So the signs are sort of on the outlier of residential District A, right? I mean, they're sort of on the outside.
Yeah, we can't get any closer to the town line that, you know, and be not in Woodbridge.
Understood, thank you.
Yes, we're on the
Thank you.
periphery of the town.
What happens to the two folks who agreed to have signs put in the yard? What happens if they sell their house?
Well, depends, I suppose. If you grant a special exception permit, that runs with the land. But I would imagine that any user would need to consent to the use of their property. So if these owners sell, a new owner, because if a special exception permit runs with the land, doesn't mean that that binds a successor of the fee interest of this property. So if I were to buy the, 1 acorn and decide I don't want this on my property, my client could not compel that owner to maintain that sign. The special permit would then expire or be abandoned by that successor in interest.
Other questions from members of the commission?
Is there a certain size sign that they don't?
Can you get a little closer?
Is there a certain size sign that they don't need to come to us for?
You want an answer to that question? So typically in a residential district, if you're having work done on your house, like you're having it roofed or painted or something like that, you can have a commercial advertising sign for that particular business while the work is being done. This particular section that deals with non-residential signs, I'm sorry to say, there's no one here standing that was here when that regulation was adopted. I was, so you just kind of have to either think I'm a liar or accept that what I'm telling you is what's happening. Quite truthfully, even the sign that Rob was talking about in front of the synagogue and other signs for churches and schools in town, all were subject to a variance from the Zoning Board of Appeals because there was no signage regulations regarding non-residential uses in residential zones, hence what you see in F. And so when they revised the regs, they revised it to include some language so that the schools and the synagogues and the churches or places of religious assembly or museums or whatever, which can be located in a residential zone, would be entitled to have signage without having to go through the rigmarole of going and showing hardship why they needed that sign. There's a little bit of background to this, and I don't know if you want me to get into that or not.
No, I was actually going to ask the applicant.
Okay. So that's just the background for why this particular section of the regulations became in place. So, here you go.
I did want to ask the applicant, you mentioned that you've already gone to the Zoning Board of Appeals. I didn't know that until you said that. If you could just give us
Yes.
some context of
So-
why you chose that route and what came of that route.
Well, there was a process started by Ms. Sullivan as the enforcement officer to say that those signs were not permitted. So it was an appeal from her. I'm going to refer to it as a decision, although it was an informal letter that was originally issued to my client. And after I got involved and I had communications with Ms. Sullivan, we agreed that since there was discussions between she and my client before I got involved, from a process standpoint, it had not really ripened to the point where an appeal should have been filed. But through discussions with Ms. Sullivan and my client, there was an agreement to take that appeal. So functionally, we were before the ZBA appealing a informal decision of the enforcement officer regarding those signs. And there was discussion amongst the ZBA about the signs and whether or not these signs would be permitted or not under your regulations. And there was a strong sense of that body that they would be, but then we kind of took a step back and agreed with Ms. Sullivan that before we get into the ZBA's decision, let's bring it to this body, which is the body that issues permits, and that's why we're here.
Right, so you weren't in front of the ZBA for a variance?
No.
Gotcha.
So if I can just summarize what you just told us.
Charlie, can you get closer to the
Sorry,
microphone?
I keep on missing it. Chris identified that the signs were not appropriately placed,
Correct.
and you contacted Chris Farm
I sent the first friendly letter. I neglected, quite honestly, to cite the version and section of the regulations, and so,
That was gonna be my next question.
yeah.
What was stated to Chris Farm that told them their sign was not right or not the appropriate sign in this?
In fairness to Ms. Sullivan, it had not ripened.
Mrs. Sullivan, I'm not a Miss.
I apologize. It hadn't ripened to that next notice cease and desist level. It was an informal letter, and I think there was a discussion between she and my client to say file an appeal if you want to file an appeal. And I don't think that, from a process standpoint, that next letter would have been what we call the cease and desist or the notice of violation, where she would have cited to chapter and verse of your regulations.
Just trying to get insight, because I'm trying to understand what the regulations say compared to what the
Right.
two sides are saying.
And you know, when they're, you know, quite frankly, this path was a path that was, quite frankly, blazed by that discussion of that body, sitting back and analyzing in great detail your regulations, which you're free to disagree with, but there was great belief that these signs, based on the way your regs are drafted, would be permitted under the special exception process.
So was there communication with the ZBA, or there was no communication with the ZBA?
There was communication with the, we appeared before that body,
Okay.
yes.
Did they
But
render any kind of decision? I don't think they did. right?
It was withdrawn. It was withdrawn.
Gotcha. Thank you.
And Chris, are you a part of that? Are you in those meetings?
Yes, because I'm a zoning officer, so I have to be there, and it was not pleasant, to do that much.
Do you concur with his assessment that the
No.
ZBA leaned towards?
When
Being
ZBA had 2 meetings regarding this, so at one meeting they received it, and there was a degree of confusion because the letter that I had written that the appeal was taken from did not cite to verse and chapter where I was coming from. It just stated that these signs are not allowed, they're not on, whatever, they're not allowed, please remove them. And then, so the first meeting was just that, and at the first meeting, because there wasn't that clarity of, and I was trying to explain in the course of the meeting where my logic was flowing from and to, which is somewhat what you've discussed here, then they wanted input from town council. So we referred it to town council, who then engaged the services of a land use attorney, who then rendered his opinion, which basically concurred with what I said, but then a member of the zoning board of appeals, who rightly said, we don't have to agree with everything that, council says, or whoever, disagreed with that opinion. And so there was discussion amongst the commission members, but there was no confirmed thing. But one of the things that they were talking about was perhaps there needed to be more clarity in the regulations, or, that it could come here to seek a variance, or not a variance, I'm sorry, to seek a special exception, and let it fall to you guys to interpret your regulations. So they were gonna have a third meeting in September, and what I did is I withdrew my original notice of whatever, so that there wasn't anything that needed to be appealed. And so here it sits with you. And that's my story, and that's the conclusion.
Thank you.
So, do we have any of the actual records of those proceedings or that town council
I was
opinion?
what I was gonna submit for the record, and I think should be incorporated into this record, is that meeting of the ZBA, where there was great discussion. It wasn't just minimal discussion, it was great discussion on your regulations. And, you might be best served listening to the arguments of the commissioner on that ZBA and the subsequent conversations. Because it was not just one member, it ultimately was 2 or 3 who started developing a consensus of under 4.6 of your regulations, this applicant should come forward and seek a special exception that they believed that this would be the proper process and that these signs should be permitted under that section. There was, so, that is, record is available on your local access
On
on
YouTube.
YouTube.
But in the interest of just, arguing both sides, so to speak, do you have a summary of what the outside counsel that was hired, at town money, that was spent to hire an outside counsel to render a legal opinion on?
I was never given a copy of that.
Oh, okay.
Could we get a copy of that?
Should
It's
we?
it's downstairs, yeah.
So, because it does sound like both from the applicant's suggestion, there has been a whole history here, and it's better, I think, to the extent we are supposed to operate under the record in front of us, is that if hearing people talk about what happened at the ZBA meeting, I'm fine with entering that. That's not something we can review tonight, and therefore, we can't make a decision tonight. We're going to add that to the record, the town council's opinion, because granted, we are in a process of updating our regulations, which are complicated and occasionally have some confusing language. Now, part of our role here, though, is to interpret that language to the best of our ability and use whatever resources we can to do so. So, Chris, if that's allowed to have that information,
You can continue your hearing, and, I can send you the link to the, or you can find it yourself, but I can send you all the link to the YouTube
question,
recording.
a question, don't we have to do things in this, do we all have to watch it together? I don't, how do we take that into the record
I'm not an
in a way?
attorney, I don't play one, but I would kind of think that if you watched it and then publicly stated when the hearing continues, much the same as if you missed a meeting and you familiarized yourself with the record, you would state.
I just want to make sure we, dot all
I
i's and
think
T's.
that ultimately, as long as this record is clear that that record is being incorporated herein, it's really for, if this ever got to a court of judicial review, for the judge to say that record is now part of this record.
And I
But
think that could be accomplished by us all stating that, yes, when we come to the next meeting, we've all taken the time to review the proceedings, related proceedings in the ZBA hearing.
And then I can just forward you the electronic version of council's review.
Yeah.
Which should be a public record.
It is a public record,
Yeah,
yeah.
but we could all read it individually, we just can't.
Correct.
You can't call me up and discuss it, that's what's prohibited.
Right, but we also need to, in this proceeding, say that we all have affirmatively done that, and that is part of the record of things that we're making our decision about. That's all I just want to make sure we were.
Gotcha.
dotting i's. Other additional questions for the applicant, because I do want to have public comment from all the folks who've taken the time to come here. Don't get me wrong, I do want, we are going to continue, which we'll have another opportunity for public comment. We'll also, I think, then have the opportunity as well for members of the public to submit written comments in addition to what they're doing today, which we're happy to take. But before you sit down, I didn't want to, if anyone had a further question for the applicant or their attorney.
No.
Hearing none? Hearing none?
No.
All right.
thank you for your time.
Thank you very much. I'd next like to then move to the public hearing portion of our public, or the public comment portion, sorry, of our public hearing for the application of Chris Farm Ice Cream. So this is part of the public hearing is for the purpose of listening to your comments. You'll have up to 3 minutes for your statements in the record. I'll give a timer which will go off in 3 minutes, but if anyone knows me, I'm always more than generous to let folks finish their thoughts and whatnot around 3 minutes. That would be appreciated. Again, as I mentioned earlier, TPZ members and the applicants will not be answering questions that you raise. This is really about getting your public statements into the record, and any written comments that were either submitted previously or can be submitted for between now and when we continue the public hearing at our next meeting. As a reminder, off-the-record communication with members of the commission on the merits of the application is prohibited. So I ask you to keep your comments brief and focused, and I welcome anyone who would like to come up and speak to sign in on the sign-in sheet. And once you're all signed in, state your name and your address, and I will then start my clock. Anyone, go right ahead. But please do sign in and introduce yourselves.
Okay. Where's the other verb? There it is. Good evening, I'm Jim Zioli. Some of you might think I said it ZBA, and I'll say it here, I'm not here as any capacity of the town of Orange. But something that came up, Chairman, that you just brought up, a similar problem to this happened in Orange years ago with a complainant that was unhappy with somebody down the road from them that was a farm that, as a new generation came on, started to do things differently. And the Orange Zoning Commission came up, it's a 3-page document that's a special exception permit just for farms. I think there's a $50 fee on it. I don't know if they've ever raised it. But within that, it lists the location. It lists, you have to list on it all of your sign locations that you desire. You have to list the products on there that you will be selling, whether it's for one season or across the entire calendar year. And things like this. All for a farm. I will be glad to provide one. We'll have Jack, I can have Jack, our zoning officer, email it to Christine so that you have one of those for something to consider. And this comes, I hadn't planned on speaking to that, but after you said you're looking at revising your regulations, it would probably make this whole process that you're facing tonight a lot easier and a lot clearer. It would be a very specific item for the few farms you have left in your community, the same as we have. I am a face of agriculture of the state of Connecticut. I sat on the Farmland Preservation Advisory Board of the state of Connecticut for 9.5 years. I was chairman of that commission for 7.5 years under Commissioner Prelli and Commissioner Ravisky. I think this is something that we work very hard towards, is preserving the farms as long as we can. As generations come along, sometimes some of them are parted out, broken up, parceled out, which we've seen for many years. Maybe you people don't even realize the very first farm in the country that experimented with artificial insemination in dairy cattle was right up the street here on Newton Road. And when I was a little kid, we used to go there because my father ran the laboratory at Griffin Hospital, and they would call him to recalibrate equipment up there for their scientific stuff that they were doing with those bulls. And I remember going there as a little kid. That was the first one in the country. In a case like this, you have a farm that is right on the boundary line, yet not in your community. It was when Woodbridge and Bethany were one part, and actually Orange, Bethany, and Woodbridge were when we all belonged to Milford. So with this boundary line that came in, creates this problem that you face tonight. It's really not a problem. Christine had a complaint which was not verifiable, so it ended up with a letter being written, sent to ZBA. For what? For a farm that sells ice cream and seasonal products. You should cherish these farms. The farms are a pre-existing, non-conforming in a residential zone. Each of our farms was there before most of the residences were built around them. Maybe the Victorian on the corner was probably there. Maybe it was part of that farm. But they're pre-existing, so they need some latitude. We have signs out for our farm at Lambert and Tyler City. We don't own the property anymore, but we still are allowed to put signs out at those corners, Orange Center and Tyler City Road. We listed that in that application that our zoning commission required each of our farms to comply with. We did, and it made the job a lot easier. You're not getting many new farms. The farms are existing. And I know the town owns the farm, but the Massaro farm, I used to chop corn on that farm and knew the Massaro brothers very, very well. But now the town owns it. Well, when you have that sign down there at Center Road and Rimmon over there for the on the farm dinner table things or the summer programs and stuff,
They're not actually on the farm property. So, are they exempt because the town owns it, but it's being run by a separate 501c3, so all of a sudden there's a gray line there that needs to be explored? But you are supporting a farm that supports the people of the area, it produces product for those people of the area, and it creates an enjoyable experience. We're not getting any more of them, so you really need to consider these signs. What impacts and problems do they create? Do they create a problem there? The property owners have no trouble with them. The business operators have an agreement with the property owners. Where is the problem? The state of Connecticut signs, I believe, unless they went up, they're $1,400 a piece. They're ugly. They're brown. They're a silhouette type sign. Most of the people I know are then adding colored placards to those for the different seasons, whether it be flowers, whether it be sweet corn, whether it be Christmas trees, whether it be pumpkins, or whether it be an ice cream cone. They then go bolting other things to it. You have two okay-looking directional signs there right now. They harm nobody except for one person who was unhappy that they were there, who doesn't even own either property that they were on. So there's probably a personal grind there that you've now gotten sucked into. But it is important for this commission to understand how few farms you still have operating in your town, same as we do in ours, and to cherish them and give a place for your families to go. And the directional sign is not the worst problem that you're going to encounter. So I urge you to support this application. I urge you to support the few farms that are left in your community. And I urge you to think 3 times on this as to how important this is to your community. It's important to the environment, it's important to the children, it's important to the families, and it's economic development. Lord knows all of our towns need that as well. So that's all I have. Thank you. I know I went way over the 3 minutes, but I appreciate your
It's okay.
latitude there.
Thank you very much. Other members of the public who would like to make public comment, please come on up and sign in if you could. Thank you.
How are you? My name is Skip Kozeski. I've lived in this town for 60 years.
Thank you, Skip. Do you mind
Could you
signing
just sign
in?
your name,
Thank
Mr.
you.
Kozeski?
Okay. Fill this out. All right, thank you. As I said before, I've lived in this town for 60 years. My children grew up in this town. I have a boy and a girl. They went to Beecher. They went to Amity. And I've had a business in this town. Very good business. And I moved here for the kids. I moved from West Hartford to here many years ago. The first time I came for this last meeting, and I understood there was a meeting before it too, I said, why? Why are we here? Is there one person, 2 people, before we went to this 495 and all these different codes and that are in your file that are in there, was there a complaint? 1, 2, or, I mean, everybody's in here. I mean, we talk about signs. If you live in Woodbridge, Orange, Bethany, Derby, Shelton, you've seen the signs because they're in everybody's front yard, let alone the 2 signs there which are located, which we're discussing. And again, it was brought up for the first time, and I heard it tonight. You got the golf course sign. Well, that's been there for, I think, as long as I've been in Woodbridge. No one's complained about it, and everybody should complain. I mean, if you want to have them take down their signs, you have children, your children can go there during Christmas, you can ride on their buggy that goes around, kids got ice cream, and everybody in here must like ice cream. If you don't, and if you haven't seen the sign, then, well, your children sure as hell do. And for anything like this, I mean, when they come out and say, well, you can't have the sign, and then directly right on the other corner, here's a sign that nobody saw, and yet let this continue on the way it is. I don't play golf, but I wouldn't knock the damn sign. So, I mean, it's, I just think it's a terrible thing that we're going on and taking your time, taxpayers' time, and asking why. I mean, you're coming, you're doing your job and going by, but things do have to change. This was written up, I believe, it mentioned last time, 2010. Well, we gotta look back at it in 2010. Why was it drawn up? Why was it written up then? So, that's all I have to say, but it would be a damn shame. You know, and every little kid growing up, you know, you go talk to your children. See how they feel about it. Take a vote. You know? I guess I'm done. Okay, I thank you.
Thank you.
Thank you.
Other members of the public who'd like to? Thank you. If you could again sign in, we
Yeah.
appreciate it.
Oh, I did bring my glasses with me. Good
Want
grief.
to borrow mine?
Address.
That's all we need is your
What's that
name and
last
the
one?
address.
Name and address? Okay. My name is Jo Haller, and actually, I wasn't here necessarily tonight for the Chris Farm signage meeting, but I was here for the Acorn Hill property. I live on 11 Acorn Hill Road in Woodbridge, and so I'll address the signs. I have no problem with those signs. They have helped direct traffic because there have been, I've lived in Woodbridge since 1976, raised my kids here, and they've enjoyed a great education at Amity and Beecher. But the traffic on 67 is wild. People go tearing through there, and it took years and years to get a traffic light. There were many bad accidents in that corner, and even after the light was put in, there were terrible accidents. It has kind of slowed down. I don't know if it's because people are driving more careful or what the situation is, but the signs aren't detracting. They're helping to direct people where they want to be. They're not slamming their brakes on at the last minute because now here's that intersection. You know, some of your GPSs say turn now. You're already on the intersection. If the sign is there giving them a heads up, they're more likely to not slam the brakes on, take a sharp left or a right, and cause other traffic situations that could lead to accidents. So I think there are so many more serious issues that face our community than signage. And I just really support that the Chris Farm should be able to keep those signs there and help our community enjoy the ice cream and enjoy safety in getting there. That's my comment. Thank you.
Thank you, Jay. Any other members of the public who would like to make public comment, please come forward and sign in. Would anyone else like to make public comment? I do note that we are going to end up continuing this public hearing until our next regularly scheduled meeting, which will be the first Monday of November 6th. So in between now and then, folks are invited to submit written comment, and we will also, as a continued public hearing, have another opportunity at that time for folks to give their 3-minute public comment again at that continued portion of our public hearing. I'll ask one more time in case anyone here tonight feels that they want to offer public comment. All right. Thank you. So I'll need a motion to continue.
So moved.
Second.
Moved and seconded. Any further discussion?
They're allowed to keep the signs where they are for now, while we're continuing.
Yeah.
Yeah. Yeah. No, the signs stay put. With that discussion, it's been moved and seconded to continue our public hearing to our next public meeting on Monday, November 6th.
Sixth.
All in favor say aye. Aye. Any opposed? Any abstentions? So we'll be back again November 6th. You have some homework assignments. Some folks have homework assignments to make sure we get the links to the ZBA actions and the town's legal opinion for this.
Thank you, Mr. Chair.
Thank you all. All right, now we can move to we have no other new business, correct, Chris?
Correct.
So we can move to our work session, and I'd like to bring in front of us the application by 9 Acorn Hill Road for a special exception permit for the excavation, removal, filling and grading. I'll give a pause while the room clears. All right, so I will, maybe I'll be ambitious and even entertain a motion to approve.
So I'll make a motion to approve the application for special exception, and then we can have discussion and comment.
Wait, so move to, like, to second? Okay,
And so check.
Do we
I was
need-
gonna ask who's
Yeah,
who's
Yeah.
actually
yeah, I
voting
mean, you've
tonight.
rotated in and whatnot, so he can,
Oh.
you need a full member, I mean, you need an alternate to fill the vacancy that we still haven't had filled of a full member on the
Okay.
commission.
So Chadi, do you
go
want to
for
be
it.
the designated alternate for this one?
Sure.
Great. So moved and seconded with Chadi sitting as our designated alternate member. Discussion on the application of 9 Acorn Hill Road.
So it seems as though all of the engineering questions and concerns were addressed. And am I correct, Chris, that there were no comments received by email, letter, or otherwise in opposition?
Nothing came in.
I agree, it seems like they have a good plan for the control of stormwater runoff and other things. That was part of the reason why we have this in our regulations, is to ensure that that excavation and grading doesn't disrupt. Thanks. And any other discussion?
I would just ask, don't forget that typically for this type of a permit, you have a bond of some form, which normally is proposed by the applicant's engineer and then reviewed by your consulting engineer for the amount. I would just
Okay.
ask that you do that.
Okay, I'll include that in my motion. Shall I restate the entire motion?
No, we've now amended your motion to include the request for a bond. So it's been moved and seconded. Chadi, if you're okay with that amendment, it was friendly. Moved and seconded. Any further discussion? Hearing none, all in favor say aye. Aye. Any opposed? Any abstentions? So if we could direct them with that additional language on the bond and
Yeah,
let
it's
them.
actually one of the requirements of your rights, but I'd just like to have you mention it when you're voting, so.
Terrific. So Chris Farm Ice Cream, we're holding off until next time.
And can we get a copy of that, form that, Orange uses?
It must be online, so, I'll get one for you.
Okay.
Are we allowed to discuss any of the Chris Farm stuff now?
No,
Because it's still an open public hearing. We can discuss the logistics of how we're going and when we're doing things, but nothing on the substance. All right. I do note that I have to pick up a kid from soccer, so I have to leave at 8:15 today. Apologies.
Sorry, the Giants started at 8:15.
and I'm not supposed to be sitting here too long without raising my legs, so it's okay with me that you don't. But I
Okay.
do need you to set an effective date for
Yes.
the regulations that you adopted at your
So-
September meeting.
When we were left to our own devices, we got it 95% correct. We forgot to set an effective date for the zoning regulation amendments that we adopted on September 5th, 2023.
How soon can that effective date be?
Please get it to the end of the month, because I'm still on part-time. I mean, this was my first day
It's
back.
like November 1st.
Yeah, something, well, yeah.
Motion for
November
November 1st.
Second.
Moved and seconded to have the November 1st be the start of those regulations. Any further discussion? Hearing none, all in favor say aye. Aye. Any opposed? Any abstentions?
And just
Well,
to give
Aaron,
you a little
do
heads
you want to
up.
be on, Aaron was on that one, just in
Oh,
case we
Aaron
needed.
was on that one?
Yeah.
Okay. Just to let you know, when they become in effect, you may have an application coming in under them.
Cool.
So,
All right, we're gonna skip cleaning up our zoning regulations.
you know, we're definitely skipping.
Yeah, Andrew,
You
any,
can skip me too if you want.
you
I-
can quickly tell us anything that happened in Scrog.
I will tell you quickly. So there was a meeting on September 14th, and at that meeting, there were a whole slew of action items, including proposed amendments, zoning amendments from the town of North Haven, the city of Milford, town of Southington, which is not actually in our district, but borders the town that it is in. Town of Guilford, town of Hampden, town of Orange, town of Cheshire, and town of North Branford. And I'll leave it at that.
That is an efficient report. Report of our housing committee.
Yeah, well, we are continuing our community conversations. I think I didn't mention this last month, but we do have a community conversation tomorrow under the Sukkah at Temple Emmanuel, talking about housing, hunger, homelessness, so it should be an interesting conversation. At our next meeting, we're gonna be looking at, the state came out, the Commission on Connecticut's Development and Future came out with major recommendations. I did send that report to you, Rob, and to Christine. It evaluates, this was commission that was evaluating policies related to land use, conservation, housing affordability, and infrastructure like sewers and things of that sort. So, it is an important report that's going to, inform what we're doing as a housing committee. They made major recommendations on statewide about the affordable housing plans. They were a little critical of them because we didn't include certain benchmarks in terms of, timelines and numbers and where and how we're actually going to build housing. We had general strategies, but they really want us to be more action-oriented in our housing plans, and that's what we're going to be focusing on, and actually identifying projects. And then I just also want to mention, this is not, well, it is related, the training on affordable housing and fair housing, that's required training for land use officials, that's still on for October 30th at the JCC at 6:30. Attorney Mark Brantz, who's a really amazing land use attorney, will be conducting that training. So that's an option for an hour. I know that Chris sent out.
Does that fulfill Kathy and Chris, like what we're supposed to be doing?
You had 2 hours that you did in the spring, so if
Yeah.
that's an hour, you're still missing an hour.
Okay.
So, I did forward to you today the other things that Scrog was gonna be offering, so I'm gonna contact them and ask if that's gonna be, taped, so that,
That is going to be taped, yeah.
so that if it's taped, then
Yeah.
as long as it's taped, I can make it available to you, and as long as you put up your hand and say you watched another hour, and tell me which hour, because I'm supposed to keep track of what you've done, and then I have to submit something to the Board of Selectmen so that they can certify that we're doing.
Right.
And this all has to be done by the end of the calendar year.
By the end of the calendar
first
year.
4
And then,
hours.
and then after that, as long as your members, any new member, I guess, has to do it. I don't know have to. If you're still staying on the commission, you then have 4 more hours to do, but you have 2 years to do it, so.
But October 30 will be accretive to our
It will
requirements.
go
We'll
towards what you
give you
need,
an hour.
1
It's-
hour,
It's,
alright.
it's just addressing the affordable housing, fair
which is
housing.
one of the required
Yeah.
components of the training
Yeah.
that you
Okay.
have to do.
Okay.
Will that be videotaped?
I probably,
We'll
I
ask.
have to, yeah.
Yeah.
I'm still working out the details of that.
Thank you. I interrupted what you were saying, so thank you.
Yeah,
Okay.
I mean, there's also gonna be, the SCROG series also has something on affordable housing and fair housing policy, but I think the event at JCC will be more a robust conversation. And it's also open to other committees and commissions. So I think it'd be, and then you'll be able to ask questions and whatnot. So I think it'd be for that particular hour, I would hope people go to the JCC event. But they are offering, I think, all components.
Thank you.
Thank you. Anything else?
No, that's it.
I have a question for Kathy. That
Sure.
housing report that you're referring to, is there anything in there that would inform our regulations in any way? Improve our regulations?
Yeah, well, the affordable housing plan did talk about how we would look at zoning to make recommendations. It didn't have specific recommendations because that was just part of the strategies. And that's what the commission wants, things more action-oriented. I mean, we did make like a recommendation, I think early on, to change the zoning regulations for the Dev 1 area to include opportunity housing. So that was one recommendation, but there's probably going to be other recommendations, particularly around our opportunity housing, because that form of inclusionary type of zoning practices, usually it's done over a long period where people are really discussing how you would do that type of policy, and I think in terms of how it was done in response to the Open Communities Alliance application, I think there's some tweaks that could be made to that. There's some like the 20% having a 20% requirement for opportunity housing sometimes makes it difficult for developments to pencil out. Like Guilford they just adopted an inclusionary zoning policy where it's 12%. That might be easier if we really want to look at increasing our affordable housing in Woodbridge.
I will send that out to everybody. It's a PDF, so I'll forward it to you.
Any further questions? Anything from our zoning enforcement officer?
No, you heard some of that.
We have minutes.
Yeah, I'll make a motion to approve the minutes of the regular meetings of July 6, 2023 and September 5, 2023.
Actually, I did have one correction I just wanted to make.
You need a second before you discuss it.
Okay.
Second.
Okay, no, go ahead.
Okay. This was in reference to,
Which minutes?
this is September 5th, last month's minutes, the work session regarding the Woodbridge Child Care Center, where I was making a comment about making a statement if there was a more intense use, such as a 3-unit single bedroom. The point I was trying to make is that we were approving uses that were more intense, like the child care center where you're allowing 100 children and staff. And my only my statement I was making that if you had something that was less intense, like if you came in with a three family 1-unit development, it would be off limits. You couldn't do it because it's on the water, public water supply watershed. But you're having intensive use of a child care center with 100 kids, and that's okay. And you have a community center where that's okay. But when it comes to housing, it's like a double standard that it's not allowed. So I just wanted to just say that was, I opined that if a less intense use.
Do you want to send me different verbiage to put in there?
Yeah, if I could do that.
I
yeah.
tried to do the best listening to what you said.
Yes. So I was, wanted to make sure. And when I was talking about public water, water expanded, it was more for, creating the community facility type of district in order to protect the public water supply. watershed area, because that is in the residential area, and there seems to be some high uses going on between the child care center and the community center. But I'll send that to you, Chris.
So, subject to the change in some verbiage that will come from Kathy to Chris. Any further discussion on the minutes? Seeing none, all in favor say aye. Aye. Any opposed? Any abstentions?
I'm abstaining. I wasn't here for the. Do you need another person to vote?
You can vote, as long as you don't make a motion when it's not you weren't here, you read them, you can read them for.
I will vote because I know my fellow commissioners read it and they're fine, so I support it. I'm in favor of them. All right, voted yes.
So I think the minutes have been approved. Any other business for the commission? Seeing none, all in favor of motion, motion to, I move to adjourn. Moved and seconded. Any further discussion? All in favor, the motion to adjourn. Aye.
Aye.
Any opposed, any abstentions? Enjoy the games.